Firstly, the court takes this opportunity to thank both the prosecution and defense counsel for their comments and insights, and also to the defendant, and for their professionalism throughout all of these proceedings in presenting their respective views. Contrary to what the court believes to be the defendant's beliefs, that her cases, both present and previous, are First Amendment cases involving an unfettered right to expound upon her positions without limitation, this court cannot disagree more. In the opinion of this court, the present case, as well as the prior cases, involve nothing more than a defendant willing to break the law to seek publicity for her cause. Publicity at any cost without any regard for the rules of society. This was never more evident to this court than during the testimony of Matthew Ryan and others, wherein it was disclosed that planning sessions are held prior to the demonstrations where at the risk of arrest is discussed and the participants are grouped according to who is willing to be arrested versus those who are not. To this court, it seems abundantly evident that if one knows there is a risk of arrest, then the activity being contemplated is most likely illegal. To this court, the demonstration participants clearly have a First Amendment right to protest, but only in a lawful manner. There are limits to our individual rights. In the opinion of this court, one person's rights will extend only as far as another's rights begin. Throughout this proceeding and the prior proceedings, this court has certainly observed an acknowledgement of these individual fundamental rights by the base personnel at the 174th Attack Wing, not only during testimony, but also in the planning and accommodations made to provide for safe areas in which the demonstrations can occur. Demonstrations have occurred without arrests until some of the participants have found it necessary to block the entranceways to the facility for the simple reason evident to this court to create conflict and media attention. Acts which are certainly calculated to force an arrest, as on prior occasions the authorities have been questioned as to whether the act would result in an arrest prior to the individual embarking on the prohibited action. This court has observed a constant testing of limits, and as we as children learn while growing up, the testing of limits can be a learning process with boundaries and consequences to be had. While the court finds the defendant to be an affable and likable person, as in any matter before this court, this is not the sole criterion to be considered by the court in reaching an appropriate sentence to be imposed. The court acknowledges receipt of the sentencing memorandum submitted by defense counsel and has had an opportunity to review the same along with the attached letters and the letters that were just attached. The court also has had an adequate opportunity to review the pre-sentence investigation report prepared by the Onondaga County Probation Department concerning the defendant, finding it, unfortunately, devoid of any appropriate substance upon which to intelligently base its conclusion. Rather than the usual in-depth analysis concerning family, environment, and social circumstances usually provided by the probation department, the report merely provides minimal background information, appearing to draw its conclusion that the nature of the offense that the defendant was convicted of really is not that big of a deal. The report fails to take into account the fact that this particular defendant, having been twice convicted by this court following trial, has intentionally, out of protest, refused to pay the fines and surcharges previously imposed by this court, despite the fact that she is clearly able to do so financially, the court having noted that she has certainly been able to post bail on behalf of her fellow co-defendants. This court recalls this particular defendant having previously declared to this court her pride in carrying on the tradition of her parents, who were involved in many earlier protests concerning other issues, and that they were friends with one of the former justices of the Supreme Court of the United States, information which escaped the probation officer in his investigation. The most useful information to this court was the statements made by the defendant to the probation officer, admitting her presence at the entrance of the base on Malloy Road. While the court understands that the defendant and her many supporters who have sent notes to this court disagree with the findings of the jury, the fact remains that the defendant has been found guilty by 6 everyday citizens who appeared to carefully weigh all of the evidence presented to them during the trial. Whether the defendant was or was not a participant in the protest is completely irrelevant to her conviction for criminal contempt second. I would remind the defendant that she was acquitted by that same jury of the disorderly conduct charge, just as her co-defendants were by Judge Jokel following a bench trial. The simple fact is that whether the defendant was present for, as she testified, for emotional support, publicity, or otherwise, she clearly admitted that she was there on the property of the 174th Attack Wing. That is in violation of the order of protection of this court previously issued. As has always been the position of this court and the understanding of the officers who have testified in this matter and previously, had the defendant remained across the street from the property, she would not have been arrested for violating the order of protection. As is clearly depicted in the video and obviously found by the jury, the defendant decided to cross the street onto the base property. To this court, if the defendant was there only to take pictures, she could have adequately done so across the street using a Zoom or otherwise. She obviously chose not to. So there is no misunderstanding. These were the choices that you, and you alone, made, fully cognizant of the consequences that could result. You and you alone placed yourself in this position. In deciding the appropriate sentence in this case, this court would remind the defendant of its sentencing comments made during her last conviction for disorderly conduct in February of this year. The court does not agree with defense counsel or the probation department that a conditional discharge is an appropriate sentence in this matter. The defendant was previously sentenced to a conditional discharge after her first conviction and willfully failed to abide by the conditions imposed by this court, particularly concerning payment of the fines and surcharges imposed. Nor is the court impressed with the notion that this defense is less serious due to its nature involving a demonstration. If that were true, where is the line to be drawn, circumscribing and deterring illegal behavior? Is a willful violation of a valid court order any less serious because it does not involve violence? Nor does this court believe that probation is an appropriate sentence. The purpose of probation is rehabilitation, offering a defendant who is in need of guidance, training, or other assistance services that can effectively be administered through probation supervision. In the opinion of this court, this defendant is clearly not in need of any of those services. It is the opinion of this court that this defendant would simply thumb her nose at the law once again if the court would sentence her to either a conditional discharge or probation, that she would fail once again to abide by the same, as in her opinion she does not agree with them. The only significant sentence that this court is left with is incarceration as the only mechanism to send a clear message to this defendant that the limits have been reached and that this court will no longer tolerate her willful actions in violation of the orders of the court. Whether she agrees or disagrees with the orders of this court, she has legal remedies available for review. But to simply disregard those orders that she does not agree with will not be tolerated by this court. The court realizes that incarceration will most certainly cause a hardship for the defendant and her family. But again, she was the one who made choices fully cognizant of the potential consequences to be had. Therefore, it is the sentence and judgment of this court as follows. This court orders the collection of and provision by you of a DNA sample pursuant to Executive Law 995-C. and hereby imposes a fine of $1,000, a mandatory state surcharge of $205, and a $50 DNA databank fee, the same to be paid on or before July 10, 2015. I am further serving upon the defendant and her attorney a summons with notice concerning the payment of the fine, surcharge, and DNA databank fee that, if left unpaid as directed, will be converted to a civil judgment after that date. I also have a copy for the prosecution.
Thank you, Your Honor.
I would also note for the record that my sentencing notes will be made part of the file in this matter. Finally, I find this to be serious because of the continued violation of the orders of this court. And it is the sentence and judgment of this court that you be sentenced to a period of 1 year at the Onondaga County Correctional Facility with credit to be given for time already served. You may appeal the sentence and judgment of this court. To do so, you must file a notice of appeal with this court in duplicate within 30 days from today, and I'm directing defense counsel to assist you if you so choose. Thereafter, you will need to perfect your appeal with the Onondaga County Court. Anything further on behalf of the people?
Judge, I would just ask for that order of protection, and the only reason I would ask for it, in addition to the other one, is for issues on appeal. Can you repeat that?
I believe the other order of protection is in place. I think this would be duplicitous. I'm going to deny the request for an order in this case. I believe the other order is to 2016. Mr. Salisbury, anything further?
Two things, Your Honor. I'm handing up to the court a notice of appeal that we're filing in this matter. The second thing,
Make a copy.
I've also handed a copy to the prosecution to serve that. I would request, I would note for the court, Your Honor, a stay of sentence is going to be filed in this matter. What I request is, given that that's going to be filed as an order to show cause to tomorrow, Your Honor, that I request that we stay implementation of the incarceration period for 1 week. That'll allow the stay to be heard by the county court. The basis for that is it's rather duplicative. If we incarcerate Mary Ann tonight, we file the stay is granted, and then she's released. It's a more efficient process. With an order to show cause, that'll be heard sometime early next week by county court. They'll decide whether or not to issue the stay. So then if we do a surrender for Thursday or Friday, based upon that, that's simply a more efficient process. So I'd ask for that.
Want to be heard, Mr. McNamara?
That's to deny it.
I'm inclined. I didn't put her in before. She was well aware that this may be the result. I'm going to deny your request for a stay of implementation. I believe a county court judge could hear it quicker than that.
Right, I understand. And I just want to make the record clear. What Your Honor was referring to is my request to just simply stay implementation of the jail sentence, not the actual stay.
Correct.
Right.
I'm going to make a copy. I've now had the notice of appeal stamped received. I'm going to make a copy of that for you. So
thank you, Your Honor.
Thank you. And for Mr. McNamara. Anything further, Mr. Salisbury?
Nothing further from us, Your Honor.
That will conclude this matter. Court stands adjourned.
All rise. Court's adjourned.
Oh, I'm sorry, Mr. Teller. Okay, so.
Rejoice in the Lord always. Again I say rejoice. Rejoice, rejoice. Again I say rejoice. Rejoice, rejoice. Again I say rejoice. Rejoice in the Lord always. Again I say rejoice. Rejoice in the Lord always. Again.
All right, folks. Gotta start clearing out now, please. Sitting on the ground, please. And anything left, please make sure you've got it there, all right? Any cameras or phones or anything like that that was left out there, just double check before you leave.
Rejoice in the Lord always. Again I say rejoice. Rejoice, rejoice. Again I say rejoice. Rejoice, rejoice. Again I say rejoice. Rejoice in the Lord always. Again I say rejoice. Rejoice in the Lord always. Again I say rejoice. Rejoice, rejoice. Again I say rejoice. Rejoice, rejoice.
All right, folks, gotta start moving towards the door. Everybody, 4